Board members, thank you. Let's go ahead and gather back together here so that we can turn our focus to law and licensing. So make sure we have a quorum here. And member Reel is online, and is member Brenton still with us as well? Okay. Let's go ahead and get started then. We are on agenda item 4. This is our Law and Licensing Committee report. We are turning time over to Chair Carey for the report out.
Thank you, Chair Hymas. Law and Licensing report, starting with item 4.2, Spectrum Academy waiver request. This is a renewal. The motion for the board is that the board approve Spectrum Academy's request for a waiver renewal from Utah Administrative Code R277-419-4.
Thank you, Chair Carey. The motion before the board then is that the board approve Spectrum Academy's request for a waiver renewal from Utah Admin Code R277-419-4. Any discussion to that? I'm not seeing any. Let's go ahead and vote. Excuse me. Member Reel, your vote?
Yes.
Yes. Thank you, Member Reel. And Member Brenton is absent or on her way. That passes unanimously with 14 yay votes, Member Brenton being absent for this vote. Back to you, Chair Carey.
Item 4.3, Iron County School District waiver request. And the motion before the board is that the board approve Iron County School District's request for a waiver renewal from Utah Administrative Code R277-484.
Thank you, Chair. So the motion before the board again is that the board approve Iron County School District's request for a waiver renewal from Utah Admin Code R277-484. Seeing no discussion, let's go ahead and vote.
Member Reel is a yes.
Thank you, Member Reel. That passes 14 in favor with 1 absent. Back to you, Chair Carey.
Thank you, Chair. With the Chair's permission, I am the lead sponsor on item 4.4 before the board, and as such, I would ask that Vice Chair Bollinger be able to oversee this part of the agenda.
Thank you. Vice Chair Bollinger. We're going to pause for a moment. We're having some technical errors. Oh, there, you're back.
Yep.
Okay, go ahead.
Okay. Thank you, Chair. So item 4.4, the motion for the board is that the board approve Board Policy 2005, Complaints Against Individual Board Members, Draft 3.
Thank you, Vice Chair Bollinger. The motion then is that the board approve Board Policy 2005, Complaints Against Individual Board Members, Draft 3. We have Member Davis, then Member Boggess.
I just have an amendment. I move that the board delete line 67 and 68. And I'll speak to that motion if I get a second.
Let's see. Sorry, let's make sure we get it on the screen here that the board strike lines 67 and 68. Is that correct?
Yes, they're the lines that read, board members may not consider materials or information not included in the packet during the executive session.
Do we have a second to that motion? I'll second. We have a second from Member Lear. Back to you, Member Davis.
Yeah, thank you. I talked a little bit with Chair Carey about this morning too, but having been involved in lots of these situations, it's a little different than kind of like a court case where someone robs a bank and you have a court hearing. It's a little more intricate with some moving parts and difficulties. And I would say that if this didn't pass, then I would move to amend the next one, which says that the packet has to be complete a week before the hearing, because sometimes things are shifting and changing, and then you really can't have a complete and full and hearty discussion if you can't have all the information. So I just feel like it needs to probably be one or the other. But anyway, there's just a lot to consider in some of these, and sometimes it's hard to capture everything in black and white on a piece of paper or, you know, in a packet. But that's why we have these confidential conversations as members together, including the person who's had whatever alleged thing against him or her can come and speak, and we can have a good, thorough conversation. Thanks.
Thank you, Member Davis. I've got a light from Member Bogus. Don't know if it's to this motion or if you're in the queue.
Well, I can comment on this motion, but I am in the queue, yes.
What would you like to do?
I would oppose this motion. And
On the record, go ahead and
on the
speak.
record, well, I would speak against the motion. Just the idea that extraneous information just comes in, and we're starting to dredge up stuff from the past and this, and I heard that and whatever. I really like the confines of putting in a box, keeping it in a box, so that we're not dealing with things that aren't related to the subject at hand. We're very focused on the allegations. I like a lot about 2005, and I would speak against removing this language.
Thank you. We've got Member Lear.
Thank you. I'm a little conflicted about this, and I remember thinking about this as we've been discussing this rule for a couple of months. On the one hand, I agree with Member Davis that bringing all of our knowledge, this isn't a court hearing, so bringing all of our knowledge to making the decision is important. On the other hand, I think the point of this was to say that the information in the packet, the respondent has also been able to see. So he or she has been able to respond to this and give that side of the story. If we bring our random experiences, knowledge, what we've heard, it would be call for us to be super responsible, maybe too responsible than we could be, understanding that we may be bringing in information that the respondent hasn't had an opportunity to tell a different side of the story. So there certainly is merit on both sides of that discussion. I wanted to second this for purposes of discussion, but that's my reservation about this, and it's really sort of impossible realistically to not bring in information, at least for your own purposes, in making this decision. But in terms of discussion, without the respondent, for sure not, maybe not there, it's, I think, or even caught off guard by something that you may have heard, I think it's unfair to bring in extraneous information. So I think I would have to go with it the way it's written, given that concern.
Thank you, Member Lear. We've got Member Carey and then Member Green.
Thank you, Chair. Yeah, I would to the motion for similar reasons, but just as a reminder to the board that we had the opportunity to write this policy because in the last legislative session there were several legislators who wanted to write this policy for us, and I believe intrude on our constitutional prerogative as a body created by the Utah Constitution. They were willing to defer to us to, as they said, no one knows the body better than us. And so this is our opportunity to show them that, yeah, we received that message. And I do believe that this finds the right balance. When we talk about that this is not a court proceeding, 100% correct, but this concept of due process extends outside of the courtroom. When I was reading the LRBI manual late last night, not the red line version, I saw that we reference due process in the LRBI manual, saying that due process has to exist in the classroom. and again, this is a fundamental aspect of due process, meaning whoever's there deserves to know what are the allegations, what am I going to see, and not be surprised by that at the time of the executive session. So thank you, Chair.
Thank you. Member Green.
Initially, Member Davis, I was thinking kind of along the same lines, only because, let's say hypothetically speaking, that we were in one of these sessions and it was being said that there was no correspondence, and when we kept inquiring and clarifying, we find out that there was not only one but two correspondence that we hadn't been shared that information, and it was helpful in that circumstance. So what would be the checks, the quality checks of due process, making sure that we have been thorough in investigations and we have all of the people involved in these situations have been given the chance to submit their responses or to submit their own personal records, and we were given the chance to, collect those and compile those into a packet, because in circumstances we've seen that wasn't done and it needed to be done. So in this rule here, what is there that will imply that we will do that fairly to board members if they're placed in this position? And that's kind of general. It's not speaking to the maker of the motion, but I would just want to know that if we were to take that out, or to keep it in, that we have been thorough in an investigation towards a board member fairly.
Thank you. Member Davis, then Member Earl.
Well, I'll wait, Chair, if that's okay, until that question is answered. But I think there's some other provisions that they've put in that might answer Member Green's question. Or do you want me to just go ahead? Because I'm probably going to make a substitute motion.
If you're going to make a substitute motion, then I don't know why we would respond to the comment on the original motion, if that makes sense.
Okay,
Let's
then-
get to it.
Okay, I'll just go ahead and make the substitute motion. Then I move that the 7-day provision include and can include minor edits up to 48 hours prior to the session.
Let's make sure we get your motion correct on the screen before we seek a second.
Yeah, and that's a valid point. I mean, I heard someone say, how do you define minor? And maybe we just say edits, may include edits. And this is because,
Should we get a second? Are you ready to speak to this, or is this
I'll
complete?
wait for a second and I'll speak to it if you get a second.
Well, so make sure, so we want to remove minor from this, is that correct?
Yeah, you can just put edits. That's going to
Okay.
be too hard to define, I think. That makes sense.
So the motion then, if I'm reading it correctly, is that the board amend the 7-day provision to include edits up to 48 hours prior to executive session. Is that correct, Member Davis?
Yes.
Do we have a second?
Point of order, and then I would second.
Sure.
Where is my line? Where's the 7-day provision? Line what?
I have it in front of me right now, but it's right after this one. 1 week prior.
Oh, 1 week. That's why I was looking for 70 somewhere. I'll second it.
Okay, we
For
have a
purposes
second.
of
Back to you, Member Davis.
Okay. If we're not going to delete what we just discussed, and I certainly went through all those arguments in my mind too. I mean, they're valid on both sides of that. But having experienced this sometimes, it also is more fair to the person being, alleged accused and the rest of the board if we do get a packet a week before, so people can look at it and say, and the member has the opportunity to respond, but things can be moving up until you literally have the executive session. And it would be unfair to the member also to be able to say, well, you know, I've done these 3 things and I did these 3 things all within this last week. I mean, there are moving parts, and I do think the bulk of whatever material is going to come should come a week before. But if there are things that happen in that last week, you really create these sort of false sense of thoroughness. And back to Member Green's point, you know, when some things weren't included that should have been, and where's the opportunity to say, why wasn't that there? There really is none if you just say you get this a week before and then it's over and you have your discussion and you don't discuss anything else outside of that.
Thank you. Member Earl.
I just have a question on the individual that has the complaint against them. If we're saying we can't consider anything, so is there a timeline when they would contribute? Because if they choose not to even come, then we would, I guess the idea is we're not, right? We wouldn't even be considering any of their information unless they provided it to leadership. I'm just trying to understand that element to it. Maybe someone could help me walk through that a little bit. What would that look like?
I think this would be independent of this motion. Is that true? I mean, I
well,
want to get your question answered, but
It has to do with that. It says board members may not consider material or information not included in the packet during executive session. So
Right.
at what point would someone include that in? And we're saying modifying it to 48 hours.
right. So she's saying, at what point would they not be able to within those
That's what
48
I'm
hours?
just asking that as if, you know, the complaint were against me. Could I include I would have to, it says I would have to include my information for it to be considered, right?
Right, and if you don't within the 1 week as is, or within 48 hours as amended, then it's no.
Right. Is it clear in here that there's a piece for the person that's responding to, does it make sense?
Can we turn to the sponsor who has been,
Okay, I just
Member
want to
Earl,
make
is that
sure
okay?
it's that we're, yep.
is it, Chair Carey, I know, like I said, he's been working on this, he turned it over to Vice Chair Bollinger to do this, he has a response, so I'd like to hear that.
Yeah, so thank you, Chair. Board Member Earl, that would be line 73, it looks like, through 76. The respondent board member may request, and it's my understanding that may be a little unclear, but it's my understanding there may be a motion to clarify that. But that is the respondent's opportunity to provide material that may not have been included in the packet put together by the board. Thank you. Thank you, Chair.
Thank you. We have a point of order, Member Davis.
I read that doesn't the person who's being complained against have the opportunity prior to the packet going out to the board? So the board puts their thing together, they allow the board member being accused to put their thing together, and that together at the same time goes out to the board, correct?
Member Carey.
The way I read it, that's how I read it, but maybe I'm wrong.
Yeah, and I'm fine with that as long as the biggest concern is that the respondent have the opportunity to review in advance the materials that are going to be presented against him or her. And
It seems more fair that that person see it before the rest of the board, so that that person's material can be included at the same time.
yeah,
Everybody gets everything.
I would agree with that.
Chair, I spoke out of turn.
Oh, I'm sorry, me too, Chair. I didn't go through the chair.
No, I hear you.
Cindy lured me into the.
Keep the
yeah.
formalities here. Yeah. So, do we? That's what I'm wondering. So we have an amendment. We have a substitute motion before the body here, and I'd love to tackle that. I know all this is connected, but let's look and restate this motion here. The motion then is somewhere. It is Member Davis's substitute motion. let's keep going. There it is. Okay, thank you. The motion then is that the board amend the 1 week provision on lines 70 through 71 to include edits up to 48 hours prior to executive session. Now, I've got member Bogus and member Lear in the queue. I've got member Green ready to speak to this motion. Is that correct? Please, member Green.
Mine again is just to clarify how this would work. So if it ends 48 hours before, I'm wondering if there is a new, if there's new materials that are submitted about, the accused or in response to, sometimes that naturally triggers an additional response or additional, evidence or other materials that they would feel would be relevant to the case per se. So do we ever actually really get to the point of not being able to speak to other materials in that executive meeting? Is this logistics that actually work?
I would, if they're willing, I would direct that to kind of the sponsor of the policy here, because from what I understand, if it's directed to the maker of the motion, she's trying to shorten that window already, to your point, right?
Yes. Yeah.
So I guess I'd ask Chair Carey if you're willing to respond to that.
Yeah, thank you, Chair. Yeah, and again, I think the paramount objective here is to make sure that the respondent receives the information in advance and is provided the opportunity to respond to it. And remember, this policy would not supersede existing policy or bylaw. So the leadership would still have the opportunity. Let's say that there's additional information that comes in 24 hours before. There's nothing to say board leadership can't say, hey, this is important, this should be considered. We're going to push back the hearing date, the executive session date, allowing the respondent additional time. So, and I understand the focus on the timeline, but, and again, understanding this is not a court case, but we see it all the time at trial where people are trying to jam in information at the very end, and the overriding concern of the court is, one, is it relevant? And does the other side have a chance to respond? If the other side doesn't have a chance to respond, that information is typically excluded because it's not fair. There's no due process. So that's what we were trying to capture here. And again, if something does come in at the very last minute, that's pertinent. Yeah, that shouldn't be ignored. But we can't let that override the respondent's rights to say, I need to see this and review it prior to it being considered. If that's the situation, I think board leadership still retains the power to set the date and time for those meetings, and it could easily bounce it back. Thank you.
Thank you. Does that answer your question?
Yeah, and can I, if I could just
Follow up?
Yeah, follow up. So giving 1 week in theory could allow more, maybe a better level of quality on fine tuning what the argument is what you're saying, versus maybe 48 hours could cause other things to be crammed in and not have enough time to sort through those details. So is your argument that a week is better than 48 hours because it allows more time for everybody involved to
I think,
prepare?
no, and I appreciate that, Board Member Green. I think the argument is it's like homework. You're not going to do it until you've got to do it, right? And so we could say a week, 2 weeks, but I think the one thing that that the timeline does do, it just gives a focal point. But if things are still happening, I think the board, I don't think there's a rush to say, let's do this. The board leadership will set this when they think it's ready. But I do like the 1 week just because it prevents that last minute filing where in 48 hours it's hard to really do anything. And the week allows that breathing room for the other side to say, oh, this is something I want to file something in opposition to, or just say, you know what, this is no big deal, let's proceed. The 48-hour window, I think, eliminates that opportunity. So I'm more comfortable with the 7 days. But again, it really could be any day. The overriding objective has to be, does the other side have a chance to respond? And I think it works both ways. If the respondent files something, then obviously the board should have the right to say, oh, well, we want to respond to that. And again, that's why I think it's so important that we limit what's discussed to the items that are filed. Because without that, you run the risk that things are just brought up for the first time where nobody has seen it before. And that just isn't due process. Thank you, Chair.
Thank you. So we have a substitute motion. We've got Member Davis's light on. Let me just get this back in front of us, that the board amend the 1 week provision on lines 70 through 71 to include edits up to 48 hours prior to executive session. We've got Member Davis, and then I think we're ready to vote. Go ahead, Member Davis.
You know, that the scenario that we just discussed, Chair is relying on that leadership actually would postpone a meeting. They don't have to. And if they don't, then this week ties everybody's hands. I mean, you and if you couple that with you can't consider anything outside of what's in this packet, it ties the hands of the respondent and of the board. And so I would just say that it remain this way to allow for that. And then the member, if the member says, this is a small change, it's fine, let's keep moving forward. But the member could also say, these are big changes, can we please have a extension on the hearing? I just think it adds some flexibility. I will not say another word. I'll let all of you have the last words and we'll just vote accordingly.
I believe that was the last word. So
There you go.
let's restate the motion one more time as they get ready to queue that up for voting. The motion then is that the board amend the 1 week provision on lines 70 to 71 to include edits up to 48 hours prior to executive session. Let's go ahead and vote.
Reel is a yes.
Thank you, Member Reel. Yeah, let's just wait a second. I can say that the motion passes 8 in favor, 7 in opposition. We're going to wait 1 second. Well, can we just have you raise your hand while this is happening so we can move forward? Raise your hand if you're in opposition, please, and we'll call out your name. Member Bogus, Member Kelly, Member Earl, Member Hall, Member Carey, Member Brinton, and Member Green. Thank you. Next in the queue, we had Member Bogus.
Okay, so I would move that the board amend this document starting at line 13 to read that internal audit ultimately, okay, so can we scroll up so the whole thing is there? Would that be acceptable? Thank you. So it would replace the shall with a may. And because this is the first time AAGs is used in this document, I think it's appropriate to insert the words Assistant Attorney Generals and then. Okay. And then insert that parenthetical there for the remainder of the document, and that would be the synthesis of the motion.
So let me make sure, at least I'm understanding, the original language is in blue. That's what's in the document already.
Mm-hmm.
Your changes are in orangish.
We'll call them rust.
Rust, thank you. And then the C, is this is an addition to read, so it says that the board amends, starting at line 13 to read, is the black language, what is that? Is that already in
That
there?
is existing language.
Okay. Oh, I see. So existing, added in draft 3, your amendments are going to be the may and the including the Assistant Attorneys General. Is that
Yes.
correct? Do we have a second to that motion? We have a second over here from Member Brinton. Back to you, Member Bogus.
Okay, so just very quickly, I discussed this with Member Carey. We had a long discussion later on in this document. The Assistant Attorney General and their cohorts are a check on the audit, and eventually they're a check on that initial process itself. And so I think mandating that they check the work they did is a little redundant. I don't want to create a space in which we disallow that engagement, but I don't think we should mandate it, especially since our internal audit department has done such good work in their processes and procedures in this area. I think we offer them that opportunity, but it's not something they have to take on. Later on, if you have read this document, you know that board leadership can engage the AAGs as well, and to keep that check on the system as independent as possible. I believe it should be a may. The rest of the speaks for itself.
Thank you. Member Carey?
I wanted to speak, but I'm in the queue for other amendments, and I'm not even sure how to do that now that I've got another one related to this, but I wanted to speak.
Sure, we'll go Member Carey, and then we'll come back to you, Member Lear.
Yeah, I just want to thank Member Bogus for reaching out. And, she made a good point, which is a lot of these maybe just be able to be reviewed by, maybe not a lot, but some of these filings may be able to be reviewed by internal audit, and they just make the determination. And to require a consultation seems superfluous, so I would support the motion.
Thank you. Member Lear?
And I had a different feeling about this, and I don't know if I should make the substitute motion. We probably need to vote on this, and then I wanted to add something because, as Member Bogus points out, this comes up in two different places, and I don't think it needs to. But I would make an argument for the shall. I think we sound a little conflicted about this whole issue. On the one hand, we want due process, and we think that's very important. On the other hand, maybe internal audit can just handle this. I think there is too much at stake for a board member, and we have some fresh examples of this. Some of us have personal examples, and we have one that was more public. But I think these kinds of allegations can do such damage to a board member's reputation and to the board as a whole that though I very much appreciate and trust internal audit, they, in doing this kind of a review, I think requires the legal minds we have who work with us daily. And I think that it's important for internal audit. I think it's important that it is a shall. Consult could be a sentence, could be, this is our plan, do you agree? So consult doesn't have to be a big conference. But I think the shall is crucial for the well-being of the respondent and also for the board's reputation. I know that if, having been involved in one of these, and again, several of us have, knowing that the AAGs were adding their legal expertise to this discussion was crucial for me. So I would support the shall, but I have a later motion to combine those two different provisions and a comment about that later, after this rises or falls.
Thank you. Okay, so the motion then is to change the shall to a may and include Assistant Attorneys General in the new language at line 13. We've got Vice Chair Wood and then Member Bogus.
I know listening to the committee discussion, there was some discussion on the may versus shall and the need for legal opinion. And there was kind of a comment by Auditor Debbie Davis that said, well, I have a lawyer on my staff. Are there different specialties that one would be more able to provide that information? Could I ask that too?
If we have somebody.
If we already have. Yeah, I'd love that clarification. Is one specialty different than another that would require us to go here or there? It's kind of critical to how I vote. Thank you.
You're good. Please, Debbie.
So
thank you.
Debbie Davis, Chief Audit Executive for the State Board of Education. So currently, the hotline specialist, he is a lawyer. Is it required that that position be a lawyer? No. So, and he's not providing legal services for the board. He's the hotline specialist. So we have the benefit of having his legal mind and his research skills, and he brings that to the table. Would that always and forever be so? Not necessarily. So that's where our AAGs, they are providing legal services for the board. So those are kind of the differences in roles and responsibilities.
Thank you. Member Bogus.
Oh, I just have my motions.
Well, I have you in the queue. If you are in the queue, I will come back to you. I've got you written down. So let's go ahead and, is this to, okay, all right. I'll get you. You don't need lights. I will get you. Okay, so the motion then is to, on line 13, change the shall to may and include assistant attorneys general before the AAGs. Let's vote. Member Reel, do you have a vote on this one?
I'm going to abstain.
Okay. We have, that motion passes, 9 in favor, 4 in opposition, 2 abstentions. Those abstaining are Member Reel and Member Davis. Those in opposition, Member Bollinger, Member Booth, Vice Chair Wood, and Member Lear. So back to Member Bogus. And can I just ask, I mean, I don't want to say how many because I don't want to seem rude, but I want to get Member Lear, who has some as well. I want to find a good balance here. We have 3 more. Should we get you in? Well, let's get you on another one here. Then we'll get Member Lear in there. So everybody's, and you have 2. Okay, let's keep going.
So I would move that on line 18, we readjust this language so that it reads more fluently. And it's really just moving words. And it would read that if sufficient merit is found warranting further review of the allegations, internal audit shall refer. And it just removes the clunky language and makes it flow better.
So we've got a motion. Do we have a second to that? Second. We've kind of spoken to it. Would you like to speak more to it?
No, I just think when we put a positive phrases without commas in weird places, it causes the reader to become confused. And so by offsetting it at the beginning of the sentence, it just reads better and provides greater clarity.
Thank you. Member Davis?
Mine's was a substantive question to the last amendment, but it may shape how I vote on future amendments. So may I ask the question? Sure. Even though it's not specific to the appositive?
Who's the question? Where's it going?
It's going to the chair, of course, because everything is directed through the chair.
That's what I was hoping for. Yeah. No, please ask the question. Let's see if we can get you an answer.
I just, this language of the last amendment was about internal audit, as if all complaints go through the hotline. So my question is, for example, my prior experience in board leadership, a lot of complaints came through board leadership, and we have, our audit folks have said that complaints can go through members or through the audit hotline through leadership. So my question is, what if the complaints go straight to leadership? Then is there some provision in this that leadership then needs to turn it to the audit department to do their thing to go back to them? Or because in my experience, what has happened in the past is the complaint will come in and then there's a question asked to the attorney generals, does this break any of the provisions in our bylaws? If so, we need to move forward. If not, we're not even going to do anything about it. And there were like 100 of those. So I'm like, how many more employees are we going to need to hire if all of those have to go through this big, long process?
Yeah, it's a great question. I might answer it incorrectly, but when we get complaints, for me personally, I treat it as if it's coming to me personally. And I don't know if we've had a complaint directed to leadership. Maybe you have in your tenure, and maybe Jenny has in hers. But typically, we would direct them if it was a complaint that we would direct them in the right setting. So if it needs to go to audit hotline, but if it comes just to one board member, I need to repent then. So I usually just reach out. But do you want to speak to that, Molly? No? Okay, never mind. So
I think almost everything goes to internal audit to do a preliminary investigation. I don't think we do too much without, at this point, we don't do too much that doesn't go.
And I apologize. I was thinking of general. You're saying if there's a complaint against a board member, that's what this policy is. So yes, I see. Let's get. Right.
Once we get them, though, I can't think of in the last two administrations any that we did not send for a preliminary investigation.
How many did you have?
No, help me out, Jen.
Is the number relevant to your voting?
It is.
No, we didn't get,
To me.
they were
because
clusters.
Board leadership should have the ability, if they're getting a lot of complaints, they should have the ability to say to AAG, look, does this cross any lines? And if they say no, then it's done. But if you get a situation where you're getting a massive influx of complaints, to have audit then do on every single one of those, that would be really big. Like, I can't even imagine historically doing that.
Okay. I mean, I'm going to expose myself here, and again, but I mean, to your point, Cindy, we've had, I know different words matter, right? If we've had, we've had instances already. We've only been doing this for 4 months, and it was a simple reach out to the board member, and it was done. It wasn't worth a 2-month investigation. It was, hey, this was reported. What's your feedback? Let's take care of this. Can you get on a microphone? And we'll get Member Earl after.
Maybe that answers my question, because this makes it sound like every complaint is going through audit, and every complaint does not go through audit. So I guess this policy is only for the complaints that start in a hotline position.
So Jay, I believe Jay, I don't have it up in front of me. I just opened up my computer. Jay covers that provision. Jay says that leadership can make some decisions here. Line 44, it says board leadership, if appropriate, may discuss or mediate the allegation with the respondent board member. Does that answer your question?
It never goes
Well,
to audit or
that's
the
the provision
AAGs.
here. It was included. And I know I've got Member Earl, Chair Carey has a comment on that, who added that. Mrs. Superintendent Dixon has a comment. So let's go here, and then Chair Carey, and then we'll go over to wherever we are here. Member Earl, Member.
So my first or third or?
He's going to respond
Okay.
to, Member Carey is going to respond to Jay, and I believe.
Yeah, thank
Go
you,
ahead.
Chair. Yeah, to address Board Member Davis's concern, and I'll start at line 5. This kicks in, as it says there, when the USBE Internal Audit Department receives an allegation. So these provisions only cover those complaints coming through audit. Correct.
Thank you for that clarification. I think as a because I spoke, I want to clarify. Board leadership can sometimes get complaints because people go to board leadership first. Board leadership then determines if it's a complaint or a concern or a gripe or an issue or an uncomfortable situation. If it rises to the level of a complaint, we generally, for due process reasons and for fairness, we generally go to our experts and our support. There are issues that we don't believe rise to the level of a grievance or complaint that we might not refer out. It might just be, oh, hey, I think you need to talk to so-and-so because I know they brought that issue up, connecting people for communication purposes. But when it rises to the level that it might be an issue, I think it's fair to say we have turned to something like this policy in order to ensure fairness and clarity in what we're doing.
Please.
When I read this, okay, it was at 5 a.m., so it was really early. That did not feel communicated to me through this policy. If that is, I'm going to reread it again right now. If that's the case, then I would feel better about it.
Thank you. Member Earl?
Just for logistics and amounts.
Member Earl, then we do have a motion before us, but we'd like to hear from Member Earl. Hopefully we can get back on track after this comment.
My
I feel
comment
like
isn't
you
on track.
always get that the caveat there.
What? Ooh, okay. Just a comment in general. Yes, there are hundreds of complaints that sometimes come in. Sometimes those hundreds of complaints are about one issue. Those are not, we don't do 100 separate items, right? If you have the same item, it's going to be, those are going to be put together. That's what internal audit has done previously. And I think that's the case is anytime previously, if something came in and it was like, oh, the complaint was serious, then we'll send it to audit because they're going to do an independent review of it. And then it would go through more of an independent analysis versus, us drilling down on it if it's something that rises to that level. So that's what I would recommend. But I'm grateful for the clarity in this policy because it helps everyone, right? So that leadership understands, okay, here's timeframes, here's direction, here's this, that's valuable. And then also for the other board members as well.
Thank you. That was great. We're back on track. So the motion then is to strike the words appropriate internal audit find sufficient merit for and replace them with sufficient merit is found warranting. So the motion would read in whole, if sufficient merit is found warranting further review of the allegations, internal audit shall ... Is there any opposition to this motion? Seeing none, we're gonna call that unanimous. And Member Reel is in her graduation, so she is not voting. Okay, Member Bogus, let's get this next one, and then we'll move to Member Lear. And we're coming back.
I was going to prepare a fourth draft. I was asked not to. All right.
Go ahead.
So I would move that we add the word permanently in subsection E, so it would eventually read, if internal audit does not find sufficient merit to the allegation to refer the preliminary analysis to board leadership, internal audit shall notify the respondent board member that the matter is permanently closed.
Okay, we see the motion before us, include the word permanently before closed on line, beginning at line 22. Do we have a second? Second. We have a second from Member Cole. Member Bogus.
I know it seems perhaps redundant, but referencing many of our experiences, I think it is necessary to put these things in the grave and leave them there, because the idea that our past can repeat itself and we bring things out of the ground into the present to try to prove a case. If it's closed, it's closed. And I think it would be appropriate for this board to include that word for clarity for the public and for the respondent board member.
are you, just a question that I have. If it's permanently closed, can we then, for example, if I show a pattern of behavior, of the specific behavior that the board deems inappropriate, can I still exhibit or show a pattern of behavior if my previous ones have been closed? Could you use that? You know what I mean? Permanently closed. So could you say, well, Matt, you've done this 3 times, and I say, actually, I haven't done it yet because it's permanently closed. The other 2 are.
So you bring up exactly what I'm concerned about. If IA and board leadership say, we find nothing to see here, this is over, it needs to be permanently done. We can't get angry about the 4th episode and try to pretend that we were wrong the first 3 times around. Do you understand what
Yeah.
I'm trying to articulate? If we've made that decision, IA says, hey, maybe you should look at this. The trifecta at board leadership says, nothing to see here, this matter's over. It needs to be done, and we shouldn't drudge it up again and say, hey, we were wrong the first 3 times. We're going to include these to try to create a pattern where we have previously determined there was none.
Sure. Thank you.
Thank you.
Member Brinton.
I just would speak to that they're finding no allegation there. So do we hold on to that when there's no evidence of wrongdoing and it's being closed? Then why would that be brought back?
Perfect. So the motion then is that the term permanently is inserted at the end of E, beginning on line 22. So it will read that the matter is permanently closed. And I do appreciate Member Bogus and Member Brinton as I read this in its entirety. It's if internal audit does not find sufficient merit. So if there is sufficient merit, it can still show a pattern of inappropriate behavior. Member Lear.
I'm kind of torn about this. Because you didn't read far enough, Matt. If internal audit does not find sufficient merit to the allegation. I'm concerned that there could be ongoing behavior that is a new instance. And I think I hate to foreclose the board's opportunity to protect its reputation if there are continuing instances of behavior. I don't mind, and maybe I should make a substitute motion, that the specific allegation is permanently closed. So that, let me just finish my thought first. So that if it happens again, and we can raise all kinds of what ifs and examples from the criminal justice system that, yes, you can't be retried for a single incident, but if you murder somebody else, you certainly the matter will be reheard. So that's my concern. And I have to throw in one other statement that I could have made in any of these comments. I had a discussion with Member Carey that he may or may not remember, but we're spending hours on this when I feel like in my 40 years of working with the board and being on the board, there were maybe 2 instances. So I think we are maybe spending too much time for the very outlying situations where most of the time board leadership, even before we had internal audit, handled these pretty effectively. So I don't want to make too much of this, but I also say if a pattern, if there is a different instance, I think that absolutely should be, we should be able to revisit that. So with that, I think I'll make a substitute motion of sorts, I guess, that we modify the, having done this exactly backwards, the statement to say that the specific allegation is permanently closed.
Thank you, Member Lear. The motion is before us. Do we have a second? Okay, we have a second. Back to you, Member Lear.
I've said my piece, thanks.
Okay, Member Bogus.
So I appreciate Member Lear, and that's exactly what I was going for. And so I appreciate the amendment and the clarity. It's that, if there is a secondary instance, let's say 2 weeks later, we treat that separate, but we can't drudge up things that we determined did not have merit to try to create something that wasn't actually there. And so I would not object to this if the body doesn't object. I would not object to this amendment. And I would defer to the maker of the draft to gather his thoughts.
We've got a light from Chair Carey.
Yeah, I think this strikes the right balance that we've been trying to find, and I think no one wants to see an unsubstantiated allegation come back to tilt the scales, but certainly new ones should be considered. So I would support the motion. Thank you.
Thank you. Seeing that we've had such discussion to this, I'd like to put it up on the board for a vote. So let's go ahead and cue that up. The substitute motion is to change the matter is permanently closed to the specific allegation is permanently closed. And with that, let's go ahead and vote. Member Reel? And who else? Member Davis? Sorry. That passes, 14 in favor, 1 absent. So thank you. Over to Member Lear for a motion, and then we will come back to Member Bogus, who has additional.
I actually had 4 amendments. I'm restraining myself to the 2 that I thought were most important. And I said a little bit about my concern generally about making too much of this policy. But I thought Chair Carey was very gracious in accepting, in fact, maybe too gracious in accepting everyone's comments. And I feel like it's a little, I feel like the whole policy now is a little bogged down and a little, doesn't read as smoothly as I wish it were. But on the other hand, everybody on the committee weighed in. So accepting that, I still have a couple of things that I think would improve it would streamline this a bit. So my first one, and I know there's some rule about going back over what we've gone over before, but I think this is different enough. So sorry, I didn't give these to anybody in advance. I meant to, Ben, so I had good intentions and then the morning got away from me.
Carol,
go ahead.
Member Lear, can I just ask, I know you've got some amendments. You've got
2.
2.
Out of my 4.
Out of your
Yes.
4. Member Bogus has a small handful additionally. Is this something that needs to consider to go back to committee?
I don't think so.
We want to tackle this now?
If you're asking me, these are not particularly controversial. I think they're more streamlining amendments.
Okay.
That's my opinion.
That's okay. I'm just asking, we're 5 minutes beyond the
Okay.
time for law and licensing, not saying this is important, and I don't want to rush it, so I want to make sure that if we're going to take the time here, let's do it. So go back to you, Member Lear.
Okay.
Sorry to interrupt.
It's all right. So I would propose, and I've got line 15 for this, so it's back to our, near our discussion of shall consult versus may consult, and may consult was the outcome, so I can still live with that. But to make this cleaner, my amendment would be beginning on line 15. Sorry about this on the fly, Ben, whoever's typing. Internal audit may consult with USBE AAGs, and we think we changed that to attorneys general, both as it begins its preliminary analysis of a complaint, that's existing language, and throughout the review and investigation process. and then we can delete lines 25 through 28.
Thank you. Let's make sure we have the motion correct before we seek a second here. And I believe we can, I believe that Member Bogus's intent was to just put the Assistant Attorneys General in front of the first AAGs as
Wherever you
they
wanna
read
put
through that,
that.
so we don't have to put it every time,
Sure.
but just to clarify,
That's not a problem.
that's,
Not the central point of the motion.
yeah.
And then did you get the delete lines 25 through 28, which repeats the involvement of the AAGs?
Does this capture your motion, Member Lear?
Oh, I can look right in front of me, sorry. Thank you, Jerry. Yes, it does, thank you.
We have a second. I would consider it as a friendly, but we have two lights to speak to this. So let's go ahead and hear from Member Bogus and then Member Green.
So I'm going to bring us back to recent memory, and we were told repeatedly, IA does not investigate, they analyze. So when we start to conflate preliminary analysis and preliminary investigation, we were told repeatedly, IA analyzes, board leadership determines whether or not there's an investigation, and the investigation is conducted by the AAGs. And that was beat into us over and over and over again. So if that is true, then this is not an appropriate amendment, and I would argue against it. If that is untrue, I would caution us to reflect on our previous practice and discuss how this would play out moving forward. Because it was my genuine understanding that there was an analysis by IA, and any investigation that took place was handled by our Assistant Attorneys General.
CAE Davis is shaking her head. That's true or untrue? True. Okay. So you're saying that, oh, now the motion is different.
Can I propose a change that might,
Let's get Carol.
so we didn't have to keep bringing up the AAGs, even though absolutely I agree with you. If we changed it to begins its preliminary analysis of the complaint and throughout the review process, does that adequately address your concerns?
Could we say analysis process?
I don't care. I think that feels a little awkward, but sure.
Yeah, it has analysis twice in one sentence.
How about just the process?
Sure. I don't think we need to keep bringing, I was trying to streamline this rather clunky policy as it played itself out. And I don't, again, not a court proceeding. Words are important, but I think review encompasses perhaps investigation, perhaps analysis, and review covers it, but analysis is fine also.
I would be amenable to this. I would not object to this, but I would object to striking the lines. So if that's going to stay in there, I would bifurcate the motion or move to bifurcate it.
Well, and there's no point in this unless you strike those lines, because the point of this is to not keep repeating that the AAGs may be consulted.
So the lines in 25 through 28 actually relate to a different part of the process. It doesn't relate to the IA process.
But it's throughout the review process, which would start with IA
We do
and end
have
with.
Member Green who's waited patiently through
All
this
right.
I
conversation.
apologize.
And so do
Yeah.
I.
Member Green.
I'll own it.
I was happy with the back and forth because they're actually answering my question. My question was, I guess, a point of clarification. Is striking line 25 through 28 a part of this motion? And I'm gathering that that is yes. And if so, it did seem that doesn't work. So would Member Lear like to clarify that, or anybody else? You guys were doing a great job, just the back and forth. You'd like to continue. I just want to know if by striking.
Member Lear, sorry.
My point is, this is not, it is important, words matter, but it's not a judicial proceeding. So in order to streamline this policy so it's understandable, everyone from the, and I always want to call you guys AI instead of IA. So everyone from the internal audit beginnings through the board leadership analysis with the assistance of the AAGs, everyone can consult them. And I was just trying to bring that together and not belabor and add extra lines to this policy. So I personally don't think that my intention was to cover all of those issues and steps.
Thank you. Member Davis.
Can they both consult with each other during both parts of the process? So can you just, it doesn't need to say and vice versa. I mean, this makes it sound like IA can only consult with attorneys through the process. Oh, I guess, but vice versa also, attorneys can reach out to IA. Is that your intention with this?
Yes, and
All right, fine.
consult to me means a back and forth. If somebody appreciates collaborate better, or I'm worried about poisoned words here, so collaborate seems okay. So does consult to me says a back and forth.
Sure.
On the, so I'm fine with that on the top, but on lines 25 to 28, then it's talking about board leadership again. And if those are the lines that Vice Chair Hart was referring to and Chair Carey, again, that indicates that they don't have the flexibility just to go to the AAGs and say, hey, can we drop this? We're not quite sure it's on the cusp. Can we drop it? Because it says, it refers back to the preliminary analysis, which seems to be referring to what audit did. But if the preliminary analysis does not include audit and leadership has the flexibility to just make a determination, then I'm fine with those lines too. But can someone answer that question?
And again, I'm doing this also like the rest of us at midnight last night, because I talked to Leanne and she'd given me some ideas that I forgot to put into writing. But if it feels more thorough to say internal audit or board leadership may consult, and it doesn't quite work because it's only IA that's involved in the preliminary analysis. So, but my intention was to say that any damn person who's involved in this process can consult with the AAGs as necessary throughout. So.
Is that an amendment?
If you were Chair Huntsman, I still have a little PTSD. You'd say, remember Lear, language. It doesn't fix it. If you want to repeat it, it's fine. I was trying to streamline. So if it's too, if it's too concerning for the rest of you, I'll stop trying to streamline and leave it alone. Right, but yeah, and that's fine. So if everybody feels better, we'll just leave lines 25 through 28, and we'll leave that part out, although it ended up lengthening this thing rather than simplifying it. But if that's the will of the body, I'm not going to force this through. But it still allows IA to consult when necessary. So let's just leave it like that and
So
go forward.
from what I understand then, the simple motion that we've discussed for the past while is we're changing shall to may. Well, not in this line, or was it this line? I don't know. Okay.
So, you know what, just maybe never mind altogether.
Okay.
IA seems to fall out of the process. And so throughout the review process doesn't really apply to IA if the rest of it, if I'm not convincing you on the other part. So never mind.
Okay.
Let me see if that was my last one. Oh, I had one more if you want. That will, that wouldn't be this. I didn't think that was complicated either.
So,
but
Member Lear, are you withdrawing this motion? It's before
I
the
can
body.
withdraw the motion. There's no
Okay.
point to it.
Do we don't,
And then we have to ask because it actually belongs to the floor.
Yeah.
See if anybody objects.
is there any opposition, board members, to withdrawing this motion that Member Lear had put forth? See, no, you cannot. See.
Well, the point is that's the IA is not involved throughout the entire process, so there's no point in. Well, that's the body's choice. I don't think it's
I
that
don't,
important.
is there, you object? Okay, let's put this to a vote then, and the motion is that we amend line 15 to read internal audit may consult with USBE attorney, assistant attorneys general, AAGs, both as it begins its preliminary analysis of the complaint and throughout the review process. And the other half disappeared.
Well, the other was just to delete the bottom two.
Delete lines 25 through
Through
28.
28.
Yeah. That's part of it. Well, that's the
And
same. We're
yeah.
withdrawing the motion,
You
but
let me
we're
take
saying
part
no,
of it out. You
there's,
didn't let me take it all away.
you can't not withdraw, then withdraw part of it. It's, that's
was
the
my point.
motion. Yeah. So we're also, along with this then, is strike lines 25 through 28. Let's vote.
Okay. Just vote. This is called over-baking, guys.
Well, I'm happy to let her withdraw her motion, but I thought we withdrew the striking of those lines without objection. I thought we removed those without objection. Oh, well then. As a point of order, sir. I believe we removed that part of the motion.
Okay, so then so I'm hearing then that the motion is the top part, not the bottom part. 25 through 28 remains. The motion then is to amend line 15, internal audit may consult with USBE Assistant Attorneys General, AAGs, both as it begins its preliminary analysis of the complaint and throughout the review process. I'm going to say let's vote. Any woes? Okay, let's vote.
Real is a yes.
Okay, we need, Real is a yes. Did we get her vote? We have one more. Remember Earl? Okay, that passes, 12 in favor, 3 in opposition. Those in opposition being Member Bogus, Member Hymas, and Member Hart. Let's continue on. You have one more, then
I
back
do.
to Member Bogus.
I do. My last one is on line 21 and 22. I think we missed a. And it would be if internal audit, let's see. If internal audit does, I'm starting above, let's see. I'm starting on line 20. If internal audit does not find sufficient merit to the allegation to refer the preliminary analysis to board leadership, internal audit shall notify the respondent board member and board leadership that the matter should be closed. Because I don't think internal audit really has the authority to do that, but
Yeah.
did we fix that, or am I just piling on?
I'm not, I can't remember what the
Well, is
amendment
that okay
was.
or not okay? It's
Can
not
we-
okay?
Can we pull up what the amended lines 21 and 22 look like, if that's okay? I know you're trying to multitask here.
But then I could amend what exists, or no? I'm having second thoughts. Should we bring this back to the committee? Well, I could
So
make
this
it
is the
better.
one where we added permanently. Is that
It's
right?
just you were too generous in your, y'all come.
So,
We actually
Member, yeah, Member Lear.
Well, yeah, in the abstract, in the,
Member Lear, you can see up here, we added the specific, where permanently is highlighted, we added the specific allegation is permanently closed. So you're saying you want to insert
well, does it
shall
make,
notify board leadership and the respondent board member.
well, doesn't it make sense to the rest of you that if internal audit doesn't find sufficient merit, that it shouldn't just tell the board member, it should let board leadership know? It just, that seems like a, oops, missed that one kind of a thing.
So can we ask whoever's driving to insert this language as Member Lear is proposing? And we have a second there as well. It's kind of been spoken to.
Yeah.
But let's make sure that we get it so we all recognize what the change will
Shall notify the
look like.
respondent board member and board leadership. And I would suggest, and tell me if you think this is bad or good, that the matter should be closed, because I feel like it's more the role of board leadership to make that decision than it is IA.
And can we change the permanently to whatever we've already voted to amend? Oh, there it is.
Should
You're
be
right. It
permanently
was just
closed.
highlighted. I gotta read. Okay. So the italicized is Member Lear's addition. Is that correct, Member Lear?
And instead of, yes, it is, but I think the is, and again, I'd like, if other people have opinions on this, it seems like it's not really IA's role to say it is closed. It's rather their role, the role of IA to advise board leadership that it should be closed permanently.
Okay, so we have Member Bogus.
Well, but it, oh, okay. And
Sorry, were you?
I am through, thank you. I was
Okay,
just-
Member Bogus.
So as this reads, I would not oppose it, but I would oppose adding anything in there that would force this to board leadership, because as this whole policy reads, it's a 3-tiered system. IA does the analysis, and they only forward it if they find merit to forward it. That's how it has read all along. So if we're forcing them to forward everything, now we're in a whole different ballgame, and then I would send it back to committee. I would move that. We do that. But if we're going with the 3-tiered system, as has been our practice, then I think if internal audit reviews an allegation and says, nothing to see here, they notify people, nothing to see here, and it's done. Now, if board leadership wants to object or whatever that might be, I think that might be dealt with in other lines, but that would be my thoughts. Thank you, sir.
Vice Chair Wood.
So doesn't B automatically refer this to board leadership immediately? Because it says if, so A says when it happens, B says if a complaint is received under A, internal audit shall notify the board member and board leadership of the nature. B automatically sends this to us.
Internal audit does not find sufficient merit to the allegation to refer the preliminary analysis to board leadership. Internal audit shall notify the respondent, board member, and board leadership that the specific allegation should be permanently closed.
No. I just don't think we want to start that practice.
Debbie, please. Hold on. Yep.
Okay, so Chief Audit Executive Debbie Davis. So currently the process is when we receive a concern, we referral and further action will be taken.
Follow-up, Chair. We need language that says that, because then otherwise you're doubling all the communications to board leadership. And everything is pending all the time. Then they have to keep track of,
And make a decision within 3 days. Or 3 business days, sorry. And I can, with a second, I can speak to that.
Do we have a second? We have a second. Back to you, Member Bogus.
So at this point in the process, we've already had days that have passed since the complaint came in, since the notification went out that there was a complaint, all of this.
I have a full-time job. And this position, unbeknownst to me, or else I would have removed my name with Joe. It was, I don't know how would be expected. It depends on the complaint. Most of them, yeah, 3 business days. I mean, I'll get it to you in 3 hours. It doesn't matter if there's, you know what I mean? But if this is telling me I have to drop everything and start my homework, right? Because
Reviewing the internal analysis, and they're making the determination as to whether or not it needs to go forward to the Attorney General's for investigation. And to me, 3 business days was enough for that. Maybe it's 5, but it needs to be expedient, because what has happened in the past is that things have been leaked to the press, and then the press puts pressure on board leadership to make a decision that often is in conflict with the decision that would have been made had we done it expediently. And so I'm worried about appropriate due process without all of the extraneous external factors that come inward. And I think that if that is the only decision, 72 hours is sufficient. But please, let's talk
We've got-
about what that looks
yeah,
like.
we've got Vice Chair Hart, and then we've got Member Davis, and then Member Earl.
Having been in a leadership seat with plenty of small issues, I wouldn't even call them grievances, they're just issues, that have come up, and a big issue. It's not, if it was one person needing to do it within 3 business days, any member of leadership will stay up all night. You know, I mean, we do that. We stay up late, we get up early to handle some business, to, what? What'd I say? I don't think there's anything that you can say less than, would 4 business days? If it came in on a Monday, would 4 business days give you technically until, because I do understand the expediency, but it's got to have a weekend. That's just the point.
We've got a few lights on here. We've got Member Davis, Member Earl, and then I know you have some questions, Member Bogus as well. So, Member Davis.
I move to postpone this back to the Law and Licensing Committee so that all of everybody's amendments can be incorporated to a seamless document in light of the processes that are used in audit and the concerns with timeframes, and that everybody feels like they can have their amendments addressed.
There's a motion to move back to committee, law and licensing specifically. Is there a second to that? I'll second. Back to Member Davis for discussion. Point of order first.
Her motion is out of order. She can make it once this motion is done, but a motion to refer to committee, it can only be done without interruption. So you have to cease the current motion and then make the motion to refer.
It sounds like you just read that.
Well, I'm taking my test in not very long, so.
Yeah. Yeah, we can ask the AAGs. I don't know where a substitute motion comes in, but as they're seeking confirmation, Member Davis, is it okay if let's continue, we're gonna sit here regardless, so let's, as they seek confirmation, let's continue on with the discussion. Are you okay with that? Yeah, it looks like, AAG Beal is, yeah. So, Member Earl, you had a light on before the motion was made. Do you want to speak to this motion that's before us?
Yeah, I would, 2 things. One, I think you could put in a timely manner or something like that. I just don't, when you restrict to that, you don't always predict when things are coming in, or, you know, timeframes or that kind of thing, or whether you can get a hold of maybe a staff member or whatever. So I would speak against this. Like I said, if you wanted to put at the end, timely manner or something like that, that just says urgency type of a thing versus here's your restrictions. Anyways, yeah.
Thank you. Member Bogus?
So I think the better thing is we need expectations. And when we build ambiguity into these policies, then we build nefarious activity into these policies. And so I think if you want 5, great, choose 5. Let's amend it and put it in there and get it done. If Member Hart wants a weekend, 5 business days would accommodate that. And let's just say within 5 business days and be finished. Then you would have Tuesday, Wednesday, Thursday, Friday, and by 5 o'clock the following Monday, a decision must be made. And I think that's fair and sporting, but without a timeline, no due process exists when you can drag things out forever and say, oh, well, we acted as soon as we could. That's not fair and sporting to the respondent board member. That we have to make a decision to be fair and sporting to both parties. And as much as I agree that you guys need that time and that this is a second job, if you will, it's also something y'all signed up for. And so that idea that making that time to get that done within a timely manner is also super important, in my opinion.
Thank you. AAGPO.
Yes, I just want to confirm on the question of referring back to committee. So Member Bogus is correct that referral back to committee can't interrupt another speaker, so it can't come in the middle of the motion. But a motion to table would set aside a pending motion. So
Thank you. Let's. So the next slide I have on is from Chair Carey here. I guess I'm trying to think of process here. We've had a motion to send back to committee. We found that was out of order. There is no motion to table yet, even though it's on the board, but the microphone was in. We're saying we go back to Member Bogus's motion, and then when the next opportunity comes up, I've got Member Davis in the queue. Is that fair? That's the process I'm following here. So with that, we're still on Member Bogus's motion to amend. I've got Chair Carey, and then Member Bogus has her light on. So go ahead.
Thank you, Chair. Yeah, I would speak against the motion. And, we talk about due process. It means two things, right? It means, yes, you don't want to leave the respondent out there in limbo, but they're also entitled to have the material reviewed thoroughly and with enough time to make this determination. And you can't predict every circumstance. You can't say that, it's always going to take 3 days or 4 days. Sometimes it's just going to take longer, and rushing that process or forcing board leadership to consult with each other when maybe that process is done better in person because they have to meet an arbitrary deadline, I think it strips away due process instead of enhancing it. And there comes a time, right? The leadership was elected by us, and there comes a time when you've just got to say, look, they're going to act in the best interest of the full board. And I believe this is one of those times when they have to be empowered to say, it's not going to take 4 days to do this right. And that's why I would speak against the motion.
Thank you. Member Bogus, back to you.
So then with that, without objection, I would strike the 3 days, but we still need the appositive phrase at the beginning because otherwise this policy requires that board leadership do something that they don't need to do. So we still need the appositive phrase in order for the policy to read as intended.
So I'd ask the board as it is before you now, is there any opposition to removing within the 3 business days? Seeing none, the motion before us then is to add if received with merit to the beginning of this line. Is there opposition to this phrase being added? Seeing none, we'll consider it added. Member Davis.
Chair, would it be appropriate to ask how many more amendments are in queue?
It is appropriate. Any thoughts? Member Bogus, can you remind us? You had a handful, I think you have about four additional ones, is that
And-
true?
I think Ben would have to say, I think there's 4 or 5.
Okay,
Some of
5,
them are they're very simple, they're just fixing grammar.
okay.
It's not.
So 5 more. But then Carol didn't do a couple of hers in interest of time. I mean, I don't want to. I don't want to take more time to postpone, but I don't want to continue with all these more amendments when we're so far past the agenda time.
We are well beyond the agenda time. So Member Bogus has some motions. Member Carey, do you have a motion or a comment? Oh, okay, I see. So, whatever
And
you'd
how
like
far
to do.
past the agenda ending time are we?
45 minutes.
And we have a hard stop.
I move to postpone
Okay, do we have a second?
and
Or-
have committee iron all these out and then bring it back.
So well, now you can make the motion to send it back to committee because we're not interrupting. And that's what it is, right? So the motion is to send back to committee. Is there a second? Yes. Back to you, Member Davis.
No, we have a hard stop today. We can't stay here all night, and we're already 45 minutes past the agenda ending time. And so I think it's time to have it go back and then come back with all of these put in with language seamlessness and especially to attention to the language of what the IA process is.
Thank you. We are speaking to the motion to send back to committee. Chair Carey.
Yeah, I would speak in opposition to that. Our committee came up with 3 drafts. We have received input from over half of the members on the board. And maybe to a fault, I sought to include that. But sending this back to committee is not going to prevent this board from making additional motions when we come back. And the one thing I'd point out, and actually it's a positive, is that almost all these motions have either passed or failed unanimously. And so there is consensus. This isn't something that we're failing to agree on. We're coming to the best language possible. That's only going to happen in this body, not in committee. So I would speak against it. There's 5 left, and let's power through it. Thank you, Chair.
Okay. Member Bogus, then Member Davis, are you still, or did you just, all right? Well, your light is on, that's why I was asking. Member Bogus, go ahead.
Well, I would also speak against the motion. If it is the will of the body to defer, I would make a substitute motion to refer it to tomorrow.
I could go for that.
That is the most I'm willing to go. I think we need to get this done. But to tomorrow afternoon at 3 p.m.
I would, I'll just speak against that, just for the sake of, if we're going to take the time and start cutting things up, we're already in the middle of this. I'd rather send a complete agenda item to tomorrow rather than separating this out. That's just my thought on that.
And I would agree. But I would speak against the motion to send it back to committee. I know it's cumbersome, and I would remind the body that I did offer a 4th draft, and I was asked to withhold that and run these one at a time. So in deference to my fellow board members, I ran these as separate amendments.
Thank you for that reminder. Let's go ahead and vote then. The motion is to move back to committee. Let's vote. Member Reel?
Real is a no.
Okay, that motion fails, and 3 were in favor of, the 3 yeses being Member Lear, Member Davis, and Member Hymas. Back to you, Member Bogus.
Thank you, sir. The next motion that I have is, I believe it's highlighted there, to amend, No, I believe it's the next one, whoever's driving. Well, it's concluded in this next motion. Is it not? Did I misunderstand that? So it would take out that if, and then it would say, board leadership shall determine whether there is sufficient merit to an allegation in violation of board bylaws, or other conduct which tends to injure the good name of the board within 10 days of receipt of the investigation. Now, you got to remember, we're down after the AAGs have done their job. And then if sufficient merit is found, then board leadership shall. So, and maybe that should say 10 business days, but the reality is it says once they get that from those people, we're dealing with a time frame that is an if. They don't have to do this unless it's there.
Okay,
Did I
so-
articulate that well?
Well, I just want to make sure your motion is correct on here. We'll get a second, and then we'll give the mic back to you.
Oh, I
So-
apologize. I kind of spoke to it. I
A
apologize.
little bit. That's fine. So is everything's correct on here?
Yes.
And do we have a second? Second? Well, if we don't have a second, we're not, okay, we have a second. And then back to Member Bogus to speak to it, and then over to Member Lear.
Okay, so if we look at the first section, the shall is to prevent things in limbo. It doesn't just sit there in perpetuity. They shall make a decision. A decision shall be made. That is, and their decision is only whether or not there's sufficient merit to an allegation. That's the only decision they're making, and the decision is 10 business days, which is well over 14 calendar days, and it just moves the process along. And then there's a qualifier, which I think is important, that if merit is found, again, it doesn't sit in limbo, it moves forward. And so I think that we need to be very clear on what moves forward and what doesn't, and keep that in the frame of the process and policy.
Thank you, Member Bogus. Member Lear?
I would move to divide unless Member Bogus wants to. I will not vote for one thing that says within 3 business days or 25 business days or 14 calendar days. This has never been a problem. There is no section in this office that is more eager to do its job quickly than internal audit. And those delays have never shown up. So to tie hands with people with full-time jobs is, I think, irresponsible, and I will vote against anything that says 10 business days or 15 hours or whatever it is. So I don't mind any of it except for that.
So let me clarify. Are you moving to divide, or are you speaking against the motion?
No, I'm saying if I'm threatening Member Bogus, if she insists on having 10 business days in there, I'm moving to divide, and I'll torture you all.
Please respond. Yeah.
So, Member Lear, I would argue that this is not talking about internal audit. This is talking about our board leadership team. And I understand that, but in recent memory, this has laid out in limbo and drug on for months, and it's not fair to the respondent board member when it hangs in limbo, and then it's dragged through the press. It's not fair and sporting. We need to make a decision, and if 14 days is not enough, then let's pick a time frame that is enough. But 10 business days equates to at or about 14 calendar days, and how long is enough to say, hey, we're going to put this before the board and do this? Dragging this out just creates trial by public perception, and it's just a mess. So if you want to bifurcate the motion, I would support that, but I do think we need clearer language throughout it.
Okay, thank you. I don't see any additional lights, so the motion then is to include the words shall and whether, and you can read that where those belong on the screen. And then also at the end of this, section to read within 10 business days of receipt if sufficient merit is found. Let's go ahead and vote. Member Reel? One more call for Member Reel. Okay. Okay, that motion fails. 8 in opposition, 5 in favor, with 2 absent, Member Reel and Member Davis. Those in favor being Member Kelly, Member Hall, Member Brinton, Member Bogus, Member Green. Back to you, Member Bogus, I believe.
I would move that we move that appositive phrase to the beginning because it's less clunky.
Yeah, so there's a motion to move, if appropriate, to the beginning of the section. Do we have a second? Second. Is there any objection? Member Carey.
I'd just like to amend the motion to amend, if that's in order. And I'd just like at the very end where it says allegation with the respondent board member, remove the period and add at any time. Thank you.
Could we, let's make sure that we get that. I'm guessing you have a second, since Vice Chair Wood, under her breath, said yes. Well, do we count those as the second? Okay. Please, Vice Chair Wood. Well, sorry. Member Carey, do you want to speak to that first, and then Vice Chair Wood? Okay.
I appreciate this so much because even in my short time, what are we at, 4 months, the few that we have had have been dealt with so quickly. It's a phone call that says, hey, this came in, explain the situation. Oh, I didn't realize, I'm sorry, done, over. I feel like we have written a whole process, and a lot of people commenting on this haven't seen the process in order. It's not a big recipe of this and then this and then this. It's a, hey, someone saw this, complained about it, didn't understand that this was happening behind the scenes, and it got resolved. So thank you for this.
Okay. So this is an amendment to amend. The motion that is before us is to add at any time to the end of the sentence. Is there any opposition to this? Seeing none, it's now included, and now we approach the original amendment to move, if appropriate, to the beginning. Member Bogus.
That we amend, in my draft it's 68, but I believe Ben as the appropriate line items.
We're gonna vote on this amendment here, that moving the if appropriate, and then we're back to you.
Oh,
Sorry.
I thought we did that without
No,
objection too.
We're gonna try that right now. So
I
with
apologize.
with the motion amended.
I'm acting
and-
in the interest of expediency. I
I
just
know
want you
you're
to know.
you're doing us all a favor.
Mhm.
So, is there any opposition to this complete amended motion? Seeing none, that passes. Back to you, Member Bogus.
Thank you, sir. I would move to amend, beginning at line 65, to simply strike the words "who has allegations pending," because to me, they are redundant and unnecessary. And then I would add the language as number 1, that the USBE and board leadership have an affirmative duty to expose and include all exculpatory information and materials which shall be included in the packet.
Go ahead, Member Brinton.
That language is not in draft 3. Who has allegations pending? It's already gone. Isn't it on
We're
65?
hearing it's on line 60.
Oh, 64.
64.
It's not on 65. Sorry.
Okay, yeah, so
Well,
it should
could-
say beginning.
So I don't know
At
who's
line
driving,
64.
but could we change that? So I guess it's 63 and 4.
63. Please, Member Lear.
He doesn't have any authority. I think it's just board leadership. Is that accurate? This information's coming
Board
to the
leadership
rest of the
has
board.
relinquished all authority to you guys, so I don't know.
So may I
this-
respond to that?
What is the question?
I'm just saying, it seems to me that looking at this quickly, it seems like this is still a board leadership process or board leadership's in charge. So the USB doesn't yet have access to exculpatory or other information, or non-exculpatory. So
Sure.
I just think you're combining the two inappropriately. It just should be board leadership,
Member, yeah,
for clarity's sake.
thank you. Member Bogus, response?
So my response would be what comes above this, since this is underneath the little 2. It's talking about our board's executive assistant, and so it could be USBE staff and board leadership, but we're actually putting in this subheading the affirmative duty of those compiling the packet. And so maybe you are correct, Member Lear, but the intent was to encompass those doing the job. And so it would include our leadership, our AAGs.
In response to that, if Matt would allow that, staff works for us, so board leadership would direct staff to do that. I don't think we need to put board staff in there. I think board leadership encompasses anyone working in that capacity.
Okay, then without objection, and I would defer to Chair Carey, but I would just say board leadership then to
There-
make things more expedient.
Well, there's nothing on the floor right yet, so
Oh.
whatever motion, you were putting a motion forward, there was a point of clarification, there hasn't been a second. I want to make sure your motion
Oh.
is clear, we'll seek a second, and then so is this what you are proposing?
Yes.
Okay, and we have a second. Back to you to speak to this, and then it sounds like Member Lear will have want to speak as well.
So I think this prevents failures of the past. And it puts us in a place where we are fair and sporting, and that, and my concern as I dialogued with Member Carey was ultimately number 3. And this would address my concerns with number 3, where we have a duty to include this information in that packet. And so if he would like to speak to the nature of it, I'll go ahead and let him do that. But we had a robust discussion and debate, and I think this is a good place where we landed.
Member Lear, you are next in line. Would you like to hear a response, or are you ready to go?
No, I just wanted to add, to
Sure.
amend this to limit the drama a little bit. Board leadership has an affirmative duty to include. I think we can do with expose.
No offense, Matt.
Exactly. Unless somebody's really desirous of exposing. No, in all seriousness, it's just.
It was initially a compound subject.
Yeah, I got it. But I think we need to delete the expose, just include.
So your amendment to the amendment is to replace expose with,
Just delete.
just delete it.
To just include is all that the board leadership needs to do.
I see. So your amendment would be to remove or strike expose and.
Yes.
Okay. Well, I don't see a light.
I agree with that.
Okay. Member Carey agrees with that. Does that mean the maker of the motion agrees with that? And does that mean the second agrees with that? Is there any opposition to that? Okay, so that's part of that. I think one more. Okay, so this is the new motion now. Member Lear, go ahead.
Just to simplify, board leadership has an affirmative duty to include all exculpatory information and materials in the packet.
In the packet, period. Is there any opposition to this? Okay, so this is the new motion then. And it's essentially we are removing who has allegations pending from the double I starting on 61. And then to change one, replace one with this new language, board leadership.
I'm sorry, not to replace.
So we would have 5 now, is that what I'm hearing? Yes, sir. Okay, so to include this as its own subsection, board leadership has an affirmative duty to include all exculpatory information and materials in the packet. It's been seconded, it's been spoken to. Member Davis.
Is it alluded to somewhere that non-exculpatory material is included in the packet? Because all it says up above is the board's assistant shall provide confidential packet inclusive of all materials to be used during executive session. But that's not defined, and down below it's defined as exculpatory information. So does it somewhere need to be included that both sets of information are included? Does that in any way exclude information that's not exculpatory? Or should there be some kind of qualifier saying like including exculpatory information? I'm looking at you lawyers over there
Not seeing any, there's,
and back there.
what about, I'm going to ask for a friend what exculpatory means.
Yeah, the person, the information in favor of the respondent. That would excuse or explain the behavior.
Sure. Thank you. I'll let my friend know.
Am I your friend now, Matt?
He's asking for himself.
Oh, I'll give you a short version. The AGs can weigh in on this if they want. But my experience is the state usually does a good job, the state being the complainant, or not really the complainant, but who's taken on the effort, does a good job of providing its information. It's usually the little guy, the respondent, who's sometimes it's not treated in a fair and sporting manner, to use a phrase we know. So, it does, the whole, I think the whole piece says that. So to me, who needs to be protected is the respondent, usually. And I think it goes without saying that the state will provide the information that it's mostly in providing which speaks for the state.
Thank you. It sounds like there's either another question or we're ready to move forward. We good? Okay. So the motion is before you on the screen. It's been stated several times. Let's go ahead and vote. Member Reel? Okay, so that passes. 14 in favor, 1 absent. Thank you. We've got one more. Back to Member Bogus.
Sorry, thank you, Chair. This would go to some of the conversation earlier in this agenda item, and so then I would move to add the words in number 5. It would add the words additional information in to line number 77. And this would allow the respondent to respond to the packet created by board leadership, and it would address the concerns that we discussed previous in this conversation.
Do we have so the motion is to include additional information in. Do we have a second to that motion? Second. We have a second. I know you spoke to it, Member Bogus. Anything else?
I don't have anything else. I just...
Okay.
Sorry.
Chair Carey, you're done. Member Davis, and then Member Earl.
I'm sorry, but the word assemble really throws me because it makes it sound like they're assembling hard copies. This is electronic, right? Chair Carey assured me it was electronic, but I just want to make sure because now I'm looking again at the word assemble.
Would you like a response from Chair Carey? His light is on.
Yeah, as I told Board Member Davis, I don't expect anyone to sit at a typewriter and pound this out. But to be clear, this is all, in my understanding, this is all transmitted electronically. And if someone wants a printed copy, like I get my copy printed, that's how I would look at it. But not mandatory that every board member be provided with a printed copy.
Yeah.
And I understand, yeah.
Well, yeah. We can change it. If you want to make a motion, that's fine, but we'll go to member Earl.
I'm just trying to make sure I understand. So, which may be necessary, it may not. That's why so I'm looking at II. Let's see, the board executive assistant shall provide a confidential packet inclusive of all material to be used during executive session by USB and the respondent board member. So then we're going to say down here that the respondent board member may request that the board executive assistant assemble and distribute the packet. Are we checking different packets, or is this the same packet?
It needs to be deleted probably. So that's why I added the language, because of the intent. Oh, may I?
Member Bogus?
So if I'm understanding Member Earl correctly, her question is the justification for the amendment. Because without that, it doesn't have a lot of, it doesn't really make sense. And I believe, based on the conversations I've had, that number 5 was added to this draft to allow a response from the respondent board member, but it's to put additional information into the packet to be distributed by the board staff to the board, and this amendment makes that clear.
Back to you,
Okay.
member Earl. Follow up.
I just have it, once again, and unless I'm misunderstanding that, it actually says that USBE and the respondent board member would be putting information into the packet. So then we're saying down here that respondent board member may request that the board's executive assistant assemble and distribute additional information in the packet. I'm not sure. I still feel like I'm missing something. Like we're putting a packet together here, but then we have an additional packet. Yeah, that's.
You feel like it's duplicative? We have some off the mic conversations.
I think like 4 is, but maybe, like I said, unless I'm missing something, I don't know if there's greater clarity up above.
Elise has a light on. Deputy Superintendent Newey.
Thanks, Chair. Just one suggestion. Maybe we could say backup instead of packet. And that is consistent with the other board items that we prepare as staff.
Would that solve what you're asking, though?
No, it doesn't. What's the board member providing materials for up above? Is that different than what they're providing additional materials for down below? That's what I'm.
So up above, I don't think the board member is providing.
Member Bogus?
It says that, though. It says that inclusive of all materials to be used during executive session by USB and the respondent board member.
So the two nouns there are objects of by. So they're preparing the information to be used by those people, as opposed to those people are preparing the information. Whereas in number 5, the respondent board member is the active noun, and they would request that additional information be provided in response to the board leadership information. So one, they are the receiver of the information, and in one, they
So
are the giver
you're
of-
suggesting it actually says inclusive of the materials. So maybe I'm still missing it, but to be used in there by these two people. You're just saying that 4 tells you how you're going to do that?
So I think you and I had the same question, and if you look at the colors, the green was added into this third
Yeah.
draft. So my question was the why, because like you, it didn't make sense. And my conversations brought to light that in one, this is board leadership's packet coming forward to the board, and then the respondent has a chance to respond to that information, and that's where it was put in number 5, which sounds great until you realize that it doesn't really make sense without the amendment, which is additional information.
All of this should be prepared before it ever.
We have Vice Chair Wood has been waiting patiently. Member Lear has been waiting patiently.
Go ahead.
Okay.
Vice Chair Wood.
Could we roll up to the motion that we made earlier with the exculpatory material. So board leadership has an affirmative duty to include all exculpatory information. So I'd like to make a substitute motion where we add to this new motion that was passed earlier. Board leadership has an affirmative duty to include all exculpatory information and additional information provided by the respondent board member in the packet.
We have a second to that. Second from Member Earl. Back to you, Vice Chair Wood, if you want to speak to that.
I think we already put in there with that past motion that we're putting in all of that which will help prove the innocence of the board member or allegations. And so anything additional that they want to add to the information that board leadership has provided will help in this.
Member Lear.
This motion if my concern goes away, but I just wanted to replace the board's executive assistant with either board staff or board leadership, because the work needs to be done, and it's done under the direction of board leadership, and I don't want to single out the executive assistant so that there's some question if the right person did it. So that seems like a without objection type of a
I'm trying to see,
concern.
at the very beginning of
I don't know
double
how
I.
often the board, I see it on 61, I see it on 58, but I'm not sure if it goes away with this new motion.
I don't think it addresses that, so let's put you in a queue to make
Okay.
that motion as a separate motion. And
That would delete number 5, sorry.
And so as part of Member Wood's substitute motion, let's make sure that we are clear on that, is to amend double I-1, add and additional information provided by the respondent board member after materials, and strike, well, it would be lines 73 through 75 of the draft 3. Is that correct? Okay. So we've got that. We have a second. I can't remember who seconded it. Member Earl did. That's right. And then okay. Let's vote. Member Reel, are you with us? Okay, we need one more. Member Booth. There it is. That passes unanimously with Member Reel absent. I believe that brings us back to the underlying motion then. And, oh, that's right. Member Lear, thank you.
Brief, and it's more of a grammatical concern that wherever board executive assistant is left, it should say either board staff, and I defer to Elise, Deputy Newey, to say, should it be board staff or should it be board leadership? But calling out an individual staff member doesn't seem necessary. Everybody works under the direction of board leadership in this case, or we can just say board staff. So which is your druthers? Okay, I would change board's executive assistant to board staff shall provide a confidential list that describes, and throughout, I don't know if it's beyond this section, but wherever it shows up in the policy.
We're getting some gratitude to my left for this amendment. Maybe. I know, you guys are so supportive. So the motion then, Member Lear, does this look correct?
Yes.
Okay, do we have a second to this motion? We have a second. Back to you, Member Lear, to speak. Okay. Seeing no lights, is there any objection to this shift? this change? Seeing none, that passes. Let's go to the underlying motion then. The underlying motion, or the motion that is before the board then, is that the board approve Board Policy 2005, Complaints Against Individual Board Members, Draft 3 as amended. And we will vote as soon as that comes up on the screen. Voting is open. Member Reel? That passes. 13 in favor, 1 in opposition, 1 absent. The 1 in opposition, Member Bogus. Thank you. Okay. This brings us to agenda item 4.5. I would like to see if we can finish out committee, Law and Licensing Committee. Lunch is ready, as far as I understand. So let's turn time back over to Chair Carey. Perfect. Vice Chair Bollinger is going to finish out the agenda. Please.
Thank you, Chair. And item number 4.5 is actually going to be discussed again at our committee meeting on Friday, so there's no action for the board. So we'd like to move to 4.6 if that's okay with you.
Yes, please.
Okay, so item 4.6, a motion for the board is that the board continue and approve R277497 School Accountability System Draft 1 on second and final reading.
Thank you, Vice Chair Bollinger. The motion then is that the board continue and approve R277-497 School Accountability System Draft 1 on second and final reading. Seeing no lights, let's go ahead and vote. Member Reel, are you with us? Okay, that passes. 14 in favor, Member Reel being absent. Vice Chair Bollinger.
Thank you, Chair. So item number 4.7, the motion for the board is that the board approve R277331 Stipends for Future Educators Draft 2 on second and final reading.
So the motion before the board is that the board approve R277-331 Stipends for Future Educators Draft 2 on second and final reading. Member sorry.
And we might have a substitute motion.
Hold on one
so
second.
Hold
We've
first.
got some lights going and some waits.
Yes, I do have it.
Member Bogus has a point of information. Go ahead.
Well, it looks like my point of information is clarified on the board.
Okay, so we have, well, I'm going to turn time over to Vice Chair Hart.
And I'm going to ask if Malia Height would come on up and speak to draft 3. I'd need to make a motion that the board adopt R277331 Stipends for Future Educators Draft 3 on second and final reading. It's a substitute motion.
Do we have a second? Second on that. Back to you, Vice Chair Hart.
And Malia Height will direct executive coordinator.
Yes, thank you, Chair. Malia Height, Executive Coordinator of Educator Licensing. The adjustments that are in Draft 3 are found on lines 42 through 45, and this was in response to feedback from our LEAs that as part of their working and administering this stipend this last school year, they incurred some significant expenses to cover their benefit costs, specifically for the employer portion of FICA and unemployment, et cetera, et cetera. So this allows us to pay for those expenses to the LEA so that they're not having to find some other way to fund those expenses.
Thank you. Member Davis.
Yeah, I just wanted to thank the committee for putting in the 30 days to distribute within 30 days because, you know, some of some districts were sending it out early and some were sending it out late. And then our student teachers were like, I have to pay my rent. And it was getting a little stressful. But my question is, what if a student teacher only, let's say, does one of the 3 months of student teaching and quits? Is there any provision in this where they need to reimburse? No. Because prior you had half at the beginning and half at the end, and I had hoped for the 30 days at least to get the first half. Did LEAs, are they the ones, Chair, that were asking for one time payment instead of two?
I think Malia has a response.
Yeah. Thank you for the question, Chair. There is not a provision that the educator, the student teacher, has to pay the monies back. This was in response to some feedback from LEAs and enormous feedback from our student teachers that were really feeling the pain. In fact, we had some student teachers that didn't receive any of their monies until after the student teaching was completed. And so this was to help attend to that.
They quit their jobs to try to do student teaching full time.
Correct. And then historically, when we look at just historically student teachers who start a student teaching experience and then maybe don't complete it, with the exception of a tiny handful of humans, like
Yes, very rare.
like 5 maybe, they come back and finish it in the subsequent semester. Maybe it wasn't a good fit, or they weren't quite ready, or things come up in life, and so then they do it again the next semester and are successful then. So we feel that this is a very low risk that will happen.
Thank you. Okay, so the Vice Chair Wood.
I just want to thank you. So help me understand, does this clarify, I know when I was in law and licensing, our biggest problem was that we were putting, many of our districts were putting these in as contracted positions. It looks like with this addition of this new language, now they will go through the system, that will take care of the benefits, and they'll actually get their full amount or close to their full amount. Is that, am I dreaming for my student teachers?
Yeah, so there are some things that we cannot prescribe in board rule, specifically how an LEA employs a student teacher for the stipend. So some LEAs will continue to hire their student teachers as contract employers on a 1099, which means they would get the full $6,000, at least the full $6,000 as is in the board rule. But they may also have to employ them as a regular employee because they're providing substitute services, or they're coaching a sport or helping out with a band after school. And so because there are some other employment considerations, the LEA has to follow the employment law regarding how they employ and pay these individuals. But their gross pay would be at least $6,000 for their student teaching stipend.
So to follow up, they still may have to pay the taxes associated with being a contractor in some cases.
Yeah, so regardless of whether they're a 1099 employee or a W-2 employee, they are required to pay income tax because it is income based on employment.
Okay, thank you.
Thank you. So the motion before the board then is that the board approve R277-331 stipends for future educators, draft 3 on second and final reading. Let's go ahead and vote. Member Reel? Okay, that passes. 13 in favor, 1 abstention coming from Member Bogus. Back to you, Vice Chair Bollinger.
Thank you, Chair. And our last action item is item number 4.8. The motion coming out of committee is that the board approve R277487 Public School Data Confidentiality and Disclosure Draft 2 on second and final reading. And with your permission and at the appropriate time, I would like to make a substitute motion.
Let's do that now.
So my substitute motion would be that the board approve R277487 Public School Data Confidentiality and Disclosure Draft 3 on second and a final reading. And I would invite Director Chalice.
Do we have a second on that?
Second.
Second. And then, yes, back to you, Vice Chair Bollinger.
Thank you.
And it looks like Ben.
Okay, it looks like Director Rasmussen will be able to speak to this for us. Thank you.
Ben Rasmussen, Director of Law and Professional Practices. The amendment in draft 3 would delete the last section of the rule. After this went through committee, staff noticed a provision in the new State Data Privacy Act that requires training for all state and public employees every year. So that will be a more rigorous requirement than just requiring teachers to get data privacy training upon relicensure. So we're recommending that you delete that last section, and then all public employees would follow the new data privacy laws the state has adopted.
Thank you. I've got a light from Member Bogus, Member Earl, then that's it.
Thank you. I appreciate the sentiment, and I did read Director Chalice's emails, and my understanding is that this has become, instead of training at the time of renewal, it's annual training. But my question is, where is it coming from? And that has just not been a question that has been answered yet, and it probably got lost in a series of communications. Are we developing it? Is it a third-party application? What is that?
Katie.
Thank you, Chair. Katie Chalice, Director of Privacy. The answer is that the Student Data Privacy team here at USB is developing that training. The Office of Data Privacy, which is separate from us, is also creating their own training, but they are allowing us to make one that's custom to education. So subject to their approval, we'll be offering that to LEAs to administer. That's how they will meet that requirement under the Government Data Privacy Act, is where the annual training requirement comes from.
So may I follow up?
You have a follow-up? Go ahead.
So this will be distributed through Public Works then, as opposed to the USB route?
The way we will be offering the course that we're creating is through Canvas, through the Canvas Commons, or through Canvas Catalog. Does that answer your question, Member Bogus?
I believe so.
Okay.
I might come back to it, but
Sure.
But thank you. I appreciate that. Are we? I guess my other question, I apologize.
Sure.
Is, are we putting that annual training in another rule?
That is not the intention of staff. Our understanding was that the preference is, if a requirement has stands alone in statute, that it was not necessary to include in rule. So we did not request the board to explore a rule to include it. But obviously, if the board wanted to, then we could help with that language.
I have no desire. I just wanted to make certain that I was clear on what was happening. Thank you.
Thank you. Member Earl.
Yeah, I am part of the data privacy, our advisory group or whatever, and they did a pretty thorough discussion on this and made these recommendations and thoughts. So I just want to let you know that that group was very thoughtful about the recommendations here. So, and the training that's coming out too. They're assisting with that a little bit. So thank you.
Thank you. So the motion before the board then is that the board approve R277-487, Public School Data Confidentiality and Disclosure, Draft 3 on second and final reading. Seeing no lights, let's take a vote. Member Reel? That passes unanimously with Member Reel being absent. Back to you, Vice Chair Bollinger.
Thank you, Chair. That concludes our law and licensing items.
Thank you. Okay, with that, let's hold on agenda item 5 and jump to agenda item lunch. I don't know what that is, 8. And we will set a timer for 30 minutes. Thank you.